Good evening, everybody. Jonathan Ginsberg here. I hope you guys are all doing well. Welcome to the Thursday night live stream. Tonight I have a guest, Chad Brown, an old friend of mine. Chad, where are you? You in? I can't remember if you're in North Carolina, South Carolina, Tennessee. Where are you at?
Yeah, it's confusing because I've lived a bunch of places.
Yep.
My office is my main office is in Mooresville, North Carolina, just north of Charlotte. We help people in North Carolina, South Carolina. We do LTD all over the country, but primarily I live in North Carolina, just north of Charlotte, and used to live in South Carolina. That's why it's confusing.
Got it. Okay. Well, welcome, and you're going to hopefully help me answer some of the questions. We get a lot of questions, so we'll go over that. And before we get started, anything interesting that you've been seeing in your Social Security cases, or anything going on of interest?
I think the biggest thing we're dealing with right now is just a lot of uncertainty from our clients. Anytime the government decides they may or may not do something, I think with all the things that happened with Trump, there's been probably a lot of bad information, but then a lot of legitimate concern from our clients. Is the process going to take longer? Is it, are they going to take away all of our Social Security disability benefits? You get sort of a lot of extreme questions, but also have a lot of, I think, realistic concern, because typically when things sort of get unstable with the government and, they reduce hiring or they freeze hiring. And so that the people that are replaced in Social Security Administration has so many people that retire every year. A lot of people don't understand, if you just freeze hiring, you create a shortfall for staff. So I think we have a lot of people worried, hey, is the process going to take longer? Is it going to be harder to get on disability? Just a lot of general sort of angst that sort of comes with just sort of the political times we're in. I don't know that necessarily the political situation we're in is going to make it that much worse than it's been the last few years, but certainly we see a lot of clients with a lot of concern for that right now. And I think there's some legitimacy to it as well.
I think so. I mean, I know from my end, I'm seeing that the cases at initial and reconsideration are taking a lot longer. It seems like the hearings are pretty quick, but initial and recon used to be 4 or 5 months. Now it's 8, 9, 10, 12 months. Recon the same. So when all is said and done, I'm trying cases, people filed it 2.5 years ago, and that's a long time to wait.
A lot of concern about Medicaid too, as they look to maybe stop Medicaid. And in North Carolina, we had Medicaid expansion. So we had a lot of people who were able to get Medicaid who weren't before. That really has helped with their claims. They didn't do that in South Carolina. We have a lot of cases in South Carolina as well. But so I think you have a lot of concern about Medicaid and retraction of Medicaid rather. And, and a lot of concerns about that as well.
Okay. All right. So let's jump into some questions, and we'll continue just discussing stuff in general. But SA, who's comes here pretty frequently, applied for migraine SSDI, not neck. I'm not sure what they mean by not neck SSDI. Neurologist referred him or her to PT for neck pain, but the neck pain doesn't cause a migraine, but said it may help. Other specialists want, I guess. Okay. So when you applied for migraines, but not for neck problems in particular. The neurologist says that neck pain may be causing some of the problem, referred to PT. And then TMJ, seeing therapists, can't afford copays, different PT for failed. He may want to try lumbar PT, don't want to have neck PT. Also don't want a new PT to try to do lumbar PT after a failed lumbar. For everyone's to go try that different. All right. So, I mean, I think big picture here, let me just say this, SA. As an attorney, we're not going to offer medical advice. I mean, you've got to really rely on your doctor. That's number one. Number two is that, if you apply for disability, you're basically applying for disability. You don't apply for a particular type of disability. So if the medical record indicates that you've got, migraine headaches and you've got neck issues, cervical issues, lumbar issues, whatever, Social Security is going to develop that kind of on its own. You can't really control what they consider to be important or what they would call severe or not severe. So, I wouldn't worry too much about, you've got to focus on getting better and listen to what the doctors say. I don't think you can control what the doctors say or what the doctors want to do. I mean, I think that, you get yourself into trouble, in my opinion, and Chad, maybe you have your own take on this, but when when a patient starts trying to tell the doctor what the patient will or will not do or doesn't think is important or not important, that's problematic. What's your take on that, Chad?
Yeah, I mean, a couple things. One, I think SA knows I have a disability expert podcast that you were on, and we interview disability lawyers all over the country. And Jonathan's going to drop his episode pretty soon, so I'm going to plug my disability expert podcast. But here's the reason.
Absolutely.
I did an interview with a guy named Daniel Bridgman. Daniel's an excellent disability lawyer from outside Charlotte, and we spent a whole 12 probably minutes on that episode just talking about how to win migraine cases. How do you develop migraine cases? He loves migraine cases. I'm 50-50 on migraine cases. Like, I mean, the problem is there's a lot of subjectivity to it, and you run into, difficulty sort of, when sometimes you have difficulty with causation, sort of what's causing it. Sort of like here you have someone who seems to have there's a little bit of trouble sort of figuring out what the cause of the migraines is, which isn't really rare. I mean, it's often we don't know exactly what's causing migraines, but one of the things that, we talked about in that podcast, though, was how important it was, one, to be in specialized treatment. So you need to see the neurologist. You need to be in specialized treatment if you have migraines. You certainly need to be trying to comply with their recommendations. So one of the questions that you sort of run into is, did the doctor tell you to do something and you actually didn't do it? And then they can sort of ding you for noncompliance, and you get into these tough situations where sometimes you're like, I don't really think this is going to help, and it's expensive, and I can't really do it. I don't really think it's going to help, and I don't want to do it, but the doctor's saying, oh, let's try it. And so I think it's really important that you're having a really detailed conversation with your doctor about what might not be treatment you think is going to work, or you have concerns about, or you have legitimate concern about cost, which is a completely different question, and whether you think you're going to actually be able to get relief from the treatment. You got to be careful with non-compliance and when your doctor's telling you to do something. But we went into pretty good detail in that show on that episode with how you develop a migraine case. Things like migraine journals are really, really helpful.
Agreed.
And they're not refuted. So like, it's not like the judge is going to say, well, there's this other migraine journal over here that says you didn't actually have migraines on these days. And so you need to document, you need to take the subjective nature of migraines, the frequency, the intensity, the duration, things that are really subjective when you're testifying about them, put them in a journal, have the journal put in your doctor's medical record, like have it put in your medical record. Tell your doctor you want this journal made part of your medical record. Have your attorney submit it for you as well. And now all of a sudden there is objective evidence that's there that's very difficult to refute and can go a long way towards helping you win those cases. I know that's not my answer to a question, but I think those are all things that she should be considering.
Yeah, absolutely. Absolutely.
I'm thinking it's a woman, but that's what I had in my
mind. Right. No, look, I've had a couple of migraine cases, and I agree they can be difficult because it is to some degree inherently subjective. But if you go to a migraine specialist and they try different medications, they try Botox, they try all the different, prophylactic medicines and the treatment medicine, and nothing seems to be working, and the doctor believes that you are giving it your all, I think that, that, like you said, can go a long way to taking what is a subjective problem, something that you report that can't be imaged, and make it into something a bit more objective. But yeah, I think with migraines, you do have to go that extra step, because you can't take an MRI of the brain usually to see a migraine. So
well, and sometimes too, you have this idea, well, I think I don't remember if it was slide 2 or 3. He said, well, I don't think this is going to work. Well, and I don't want to keep paying for it. One of the things you could say is that if you do go and you go to several appointments and you go to 3 or 4 appointments and it fails, that actually becomes positive evidence, because now you're showing I'm exhausting the options that are available to me to be able to get relief from the pain. And yet despite my best efforts and medical treatment, it's still there. And that's a much more difficult case for the judge to deny and sort of marginalize your symptoms.
Yep. I agree.
So I think that can certainly be helpful. I know you may not want to go, but if you do go and it's not helpful, I mean, that $120 for 4 visits could actually be money pretty well spent in terms of case development.
I would agree with you. You've got to be very careful about what they call non-compliance. Okay,
Yeah.
let's move on. Christina, who's a regular. Hello, Christina. Christina is one of my um, a big fan. We'll call her a big fan. She's here
Yeah.
every week. And
I'm a big fan, so Christina and I got a lot in common.
okay, there you go. There you go. All right. Well, Christina, hello. And I'm glad to see you here again. Joe, G.I. Jose, or Joe, and we've emailed a little bit back and forth. And he suggests the essay to have the doctor write a letter talking about the severity of conditions. Yeah, as far as the PT appointments interfering with work schedule, of course, if you're working, that raises a whole different level. I mean, certainly having a narrative report from a doctor can be helpful. But again, the doctor needs to be talking about, what he or she perceives to be your limitations in light of the treatment you're undertaking, your compliance with it, and the fact that you've been doing everything the doctor is being said. Simply a letter from a doctor saying, I think SA is disabled is not going to be enough. You got to have ongoing kind of treatment records. So, all right.
Sure.
So we've got a little bit of back and forth there. We'll leave it at that as it is. Spine surgery journey with a very impressive beard says, I talked to my adjuster today, or adjudicator today, said they'll have a decision next week. Do I think it's a good sign that they talked to you about it? I'll start it with a letter with a number to call. I don't know that you can draw any conclusions. People say to me, well, I'm seeing on my online portal that I'm at stage 3 or I'm at stage 4. I think you may have talked about this in one of your videos. That doesn't really, it could mean anything. I mean, stage 3 could last 3 weeks or it could last 6 months.
Yeah, I mean, it's difficult. It's real difficult to take much from the fact that you're going to get a decision. I think it's always better to get a decision, because good or bad, if it's a good decision, then you win. If it's a bad decision, at least you can move on to the next step. So,
right.
a lot of times it has to do, I don't know. I mean, I could probably tell you internally if we have a case and I know the facts of the case and how long it's been at a certain stage. Sometimes that gives us some indication. Generally, if your case has been there for like 3 or 4 weeks and you're getting a letter okay, it's probably not a good sign. Probably means you're losing and you're going to go on to the next stage. Sometimes quick is not good. If it's been there forever, I don't know, it probably go either way. It may just mean they just now got to it, but I wouldn't take too much away from it, except I think it's a good thing you're getting a decision either way, because if you've got serious problems, you either need to get it resolved or you need to be able to move on to the next stage to have a better shot to get it resolved with an ALJ.
Yeah, I would agree. I mean, is your experience? My experience has always been that initial and recon, usually those are cases that are listing level. They're going to get caught, or maybe one where it's just a clearly a grid rule case.
Yeah.
But a lot of legitimate cases are denied at initial and recon because they don't meet a listing or they don't meet a grid rule. But it's still a very legitimate case, and you win at the hearing. So I agree with you. I mean, I'd rather get a denial quickly and move on so we can get in front of somebody who can make a decision, because
for sure.
I mean, my experience is the adjudicators many times, and we've had some adjudicators come on, and maybe if somebody's on who is or has been an adjudicator can tell us, but I mean, they don't have a lot of discretion in some regards. They're subject to the opinions of the medical specialists that work in their office, and I suspect there are probably some requirements that they have in terms of what they do, from their supervisors. But I want these cases to move forward. If you can't win early, get it denied. Let's move to the next step.
Yeah. Ironically, Daniel Bridgman, the guy that was on my podcast, he talked about migraines. He was also a DDS examiner before he went to law school.
Okay.
And he talks a little bit in that episode about sort of the process and what they went through and how they make decisions. I think one of the things people don't understand is, by and large, they have more work to do than they can do at disability determination services. So if you can, I think this is true. I've done this a long time. I think this is true. So imagine if you have to resolve 40 cases a week, give or take, okay? And you work 40 hours a week. And let's just say you're a perfectly efficient employee. You're a star employee. You actually work 40 hours a week. But it takes 2 hours to process an approval or 3 hours to process an approval. So let's just say that they pay 25% of the cases that they hear, because that's about what gets approved at initial. I think it's 29 or maybe it's 32. I can't.
I think it's right in the early low 30s. Right.
Let's just say it's 25 for good math, for easy math. So you got to do 40, and you're going to pay 10, and it takes 2.5 hours per case to do that. Well, that's 25 hours, but yet you still have to resolve 30 other cases. So if you were in that job, what would you do? I tell you what I'd do. I'd go and find as many cases as I could to deny as quickly as possible. Red flags, work, drugs, age, i.e. under 50.
Right.
I would look and say, how many of these can I sort of give a rubber stamp to move on through the process so I can actually focus on the ones that have a chance to be paid? And when you understand that's most likely what's happening at most DDS evaluation, what their work week looks like, you start to understand, well, I don't understand how that my case got denied. Well, your case got denied because it didn't fit in a perfect pattern to be approved in the 2 hours they had to work on the 10 approvals they're going to do this week. And I've never had a DDS examiner tell me exactly that's what they do, but mathematically they can't do it any other way.
Well, it's funny, I've been doing my pre-hearing briefs. I try to do in every case. And, more recently I've been looking at the section A, which is where the DDS gives its explanation. The reason I'm doing that is because many times they will limit a person to, let's say, a light RFC or a sedentary RFC or some sort of version of that, or they'll come up with the DOT code for their past job. And I find that useful, especially if they limit a person, let's say, to sedentary work or light work, and then deny it because they can go back to their past relevant work. Well, you're exactly right. They typically will deny it because, well, it looks like there's transferable skills, even though the person may have all kind of, maybe taking 15 different medications.
They'll misclassify the job so they can make it skilled, so they can, because that's an easy denial, because we'll say we've got transferable skills. Or,
that's exactly.
Or heaven forbid you miss an appointment. You miss an appointment. You miss an appointment with the examiner to have a CE done, and it's like, okay, non-compliance denied.
That's my exact point, is that when you look at the reasons they deny it, it's just like, you can tell if you read between the lines, I got to get this thing out. This is fast and easy way to do it, and let somebody else worry about it. That is exactly what I'm saying.
For sure.
I had one, today, my hearing today, which is going to get approved. I was looking at the DDS determination, and this gentleman had a lot of skills. He was a managerial position. Okay, managerial position, transferable skills, boom. Setting aside the fact that he's had 5 back surgeries, failed back syndrome. He's got all kind of non-exertional impairments. I mean, it's like, are you looking at the record? I mean, it just doesn't make any sense. And the judge even said to me, before the hearing, we had a little bit of a pre-hearing, is like, because I'm looking at your guy, he's 60 years old, and it was like 59 or something. And actually he was 60 at onset. He's limited to light work by DDS. Because even if that's the case, he goes, what kind of transferable skills could this guy have with what I'm sure the level of pain he's in? He's using a cane, he's using a walker, but that's, like you said, that's what they do to move it along. And I sympathize with them. I mean, they got a lot of work to do, but, I think a lot of people end up waiting a really long time because it's just faster just to deny it and move on.
And sometimes people, sometimes we'll have clients too, and they get real frustrated that they got denied quickly. And I'm like, don't be frustrated. Like, if I agree you should have been approved, but most people aren't. You'd rather than deny you quickly so you can move on through the process.
And also,
I got to fix my battery and camera. I'm not going anywhere.
That's fine. I know you had an issue with the battery. That's actually a very good point, is that, people, you should never take it personally. If you get denied, it's not because somebody, adjudicator at DDS is looking at it and saying, Joe Smith, I don't like you, for whatever reason. That's not the way it is. It's just, they've got, as Chad said, they've got a lot of work to do, and it's just a lot easier to say, boom, we're going to go ahead and deny it. Okay, so Chad had to replug in. He told me before we went on that there was, let me just remove him real quickly from this. When he gets back on, I'll bring him back on. But he had to get his battery, battery was running out, so he had to plug it in. Okay, we'll deal with this. Oh, there he's back. Okay, got you back there. Okay, so you got your battery.
All right, we're trying.
Okay, there you go. You got your battery.
Now I got to plug. I got to plug my power in. Then I'll be good.
Okay, there you go. Yeah. I'm actually on a desktop. I have my downstairs home office. I have a desktop, and I have laptops every place else, but I still have have a desktop, which is my main production machine where I work at for the most part. All right, Kevin Johnson says, "Good evening from Tennessee. Waiting for a hearing date." Kevin, how long have you been waiting? I'm curious. I'm finding that when I request a hearing, I'm usually getting one 5 or 6 months. So I'm curious as to how long you've been waiting. Heather W. Heather here. With past substance abuse, mental health, migraines, no questions from the VE or ALJ. I guess we were talking in previous weeks, said you shouldn't worry. 3 weeks later today, the case closed, decision in the mail. Is that good? Well, again, it's always better to see black and white that you've been approved. I mean, you don't want to, you don't want to have a situation where, you don't know, and it's just kind of up in limbo. But I think that if the judge had no questions, generally, no VE questions, that means that you probably won, or if the judge is going to say there's just nothing there. So if there's something there, some good evidence, that's probably a pretty good sign. I would also point out that for a judge to deny you, he or she has to justify that denial. In the decision. So, if a judge doesn't ask you any questions and issues a denial, there needs to be some pretty good reason for that. So you're the person with the substance abuse, mental health, case closed. Again, I think it just, I don't like to predict without knowing what happened at the hearing. Look, substance abuse is always a concern if it's in the past and the evidence shows that you have managed to overcome that you're no longer you're sober. I think that's a really good sign. If it's ongoing, that's problematic. Mental health, again, is one of these areas, and I'm curious as to what you think. I always tell people, in my mind, if you have a mental health case, Social Security is looking for what I would call indicia of severity, things like inpatient hospitalizations, suicide attempts, multiple failed medication trials. Mild depression, moderate depression usually are not enough. It's got to be something more than that. Again, migraines, as we talked about before, you've got to have evidence of severity, treatment with a specialist, a diary, things like that. So, Heather, I would say there seems to be a certain level of subjective complaints in what you're talking about. But again, if the record is really strong, and the judge had no questions of the VE and no questions really of you, it could be a good sign, but we can't really tell based on this, I don't think.
Yeah, I mean, I would be, I would put it in the win category if you forced me to bet. Like you said, put your chips on one side if they don't ask any questions.
Right.
I mean, generally, if they don't ask any questions, it's usually because
it's obvious one way or the other. Right.
Yeah, I mean, but if they don't ask any questions, then, I mean, if they didn't ask the vocational expert any questions, then sort of the question becomes, well, how are they going to produce vocational expert testimony? Now, granted, you can deny someone at step 5 without specific vocational expert testimony as long as you fit in one of the categories, sort of like they do at DDS. And some judges will do that, but typically they won't. I mean, I think it's, I believe it. I also had disputed cases where they told me we were going to win and we got a denial.
Yeah. And just say when you're talking about step 5, Social Security has something called a 5-step sequential evaluation process. Right. Step 1 is, just to go over it, step 1 is, are you working? At what they call SGA level. Are you working? If you're working and you're earning more than $1,620 a month in 2025, then by definition, you're not disabled. Number 2 is, do you have a severe condition? And this is where judges will deny cases because they're saying you make all these allegations, but nothing here is clearly diagnosed. There's nothing here to suggest would cause more than a minimal impediment to your working. It's non-severe. And I've had judges deny cases saying all of the allegations are non-severe. But again, if you've had treatment, if there's any sort of objective evidence, that's hard to really deny it, saying it's non-severe. And again, I've seen DDS do this, where they'll call, my client's mental health condition non-severe when the person's taking prescription medications, they've been seen by a psychiatrist, and clearly there is something going on there. So I think, that you can get past that. Step 3 of the sequential process is, do you meet a listing? Very, very hard to do, but they have to go through that. And by the way, my take on it with the listings, and I've got a website called meetalisting.com. If Social Security has identified a condition as being in the listings, that basically says they recognize it as potentially a disabling condition. Conditions like fibromyalgia that are not in the listings are a little more of an uphill battle because they're not even in the book. If it's in the book, heart disease, musculoskeletal problems, kidney disease, these are all at least, they recognize that potentially there's a work preclusive problem. Not in the book, it's further more difficult to prove. Step 4 is, can you return to your past relevant work? Step 5 is, can you do any work? In most cases, at least I'm saying, if they're denied, they're going to be denied at step 4, saying you can return to your past work, or step 5, that there are other jobs that you could do. So, it really depends on what the judge wants to do. If it's step 2 denial, there may be grounds to appeal that. I think that's step 2, when I started doing this, was kind of a non-factor. I don't know if you remember those days. It was like everybody could prove it was something was severe. But now you see denials at step 2. But bottom line,
they're usually error.
Yeah,
right.
I think
We used to allow prosecutors a long
appeal.
time ago. You'd say you get a grand jury to indict a ham sandwich. You
Yep.
can't get. Anything that has any impact at all on your ability to work theoretically should qualify at step 2. So it's very.
Although, let me just raise this point as well, because people sometimes will ask questions about appeal. And, I've seen cases where the denial was at step 2, and there was clearly evidence that there was some impediment to working because of that condition. However, was there enough to disable the person? So, you could appeal it and say, well, this should not have been a step 2 denial, maybe get a remand. But at the end of the day, are you going to win? So, you got to look at that as well, is that, just because there's an error, is it going to be enough to help you win? You don't want to have to go through the whole process, go back to another hearing. Then the judge says, okay, we'll give you that it's severe. We're going to deny you at step 4 or 5. So you got to look at that as well when you do appeal. But hopefully, Heather, there's enough there where, a judge is going to look at it and say, the substance abuse is not a material contributing factor. The evidence is strong enough to say, yes, that you would have a really hard time being reliable. I would feel more comfortable if the judge would ask the vocational witness a question that included, that off-task language or missed days from work language, just to kind of firm it up. My experience, if the judge asks the question, the VE, the only question he or she asks is, this hypothetical person will be off task 15% of the day or miss 2 or more days of work per month. And that's the only question the judge asks. That's usually a pretty good sign. I get a little nervous when they don't ask any questions, but, I'm sure you'll tell us in weeks to come what happened, but that's my take on it. All right. Kevin says,
what else we got?
Okay. Can an ALJ ever turn a denied recon if you find something wrong with that decision?
Man,
Absolutely.
I hope so.
Yeah. Otherwise we wouldn't have a job, right?
Yeah, sure. Yeah, absolutely they can.
Yeah. In fact, judges will say at the beginning of a hearing, I'm not bound by any of the prior decisions. I'm taking what is called a de novo or brand new look at all this. So yes, look, at initial and recon, you're dealing with adjudicators who work really hard, or almost certainly overworked, but they don't have the authority in many cases to make judgment calls about somebody's functional capacity. That's really something that a judge has to do. And, so I think to some degree, the adjudicator's hands are tied, and the judge doesn't have those limitations, a lot more autonomy. So yes, a judge will take a brand new look and is not bound in any way, shape, or form by what the adjudicator says, although they look at it. And, I think that, I look at it too, because I want to see if the adjudicator limited the claimant to, sedentary or light work. I'm going to make that point in my brief so that the judge doesn't start talking about medium level work. So at least, let them know that Social Security's already kind of looked at that.
Yeah. And don't walk away from initial or reconsideration, initial being the first stage and reconsideration being the second stage, I mean, clearly don't walk away from that denial believing that that means you're not disabled.
Mm-hmm.
That's not an accurate conclusion from
Right.
receiving a
Right.
recon denial. So don't,
You know, and
don't be disheartened by that.
Right. And when you stepped away, I made the point that you should never take it personally. I know it's very hard, not to take it personally. You get this form letter that says, we've looked, it says this royal we've looked at the evidence and we've decided that you're not disabled, or you could return to past work or the other jobs.
The singular overworked we made the decision.
Yeah. Yeah. In fact, I was one time on a radio show with a Social Security, regional commissioner. And he's like, and somebody called in and said, I got this letter and blah, blah. He goes, look, I know, I'm sure that if I got one of these letters, I would be offended by it because I'm living this nightmare, where I've got all these problems, and some faceless bureaucrat someplace sends me a form letter saying that, I can't work, and it's got my signature on it, basically. So again, don't take it personally. That's where you definitely want to talk to an attorney, get some advice about whether to appeal it or not, and what the argument you would have to appeal. Because again, I think a lot of folks go into this, and maybe this is something we can talk about a little bit. When you apply for benefits, and I will tell you, when I started doing this kind of work, I didn't understand this myself. It's real tempting to think this is about your medical problem. And if you look at the listings, these are all talking about medical issues. But the reality is Social Security disability is about vocational capacity, about your ability to work. And so if you don't really focus on your ability to work and how your medical problems impact that, you're missing the point. And I look at, these, because I always read the forms that the claimants fill out, and I'll see things like, I can't sit for any length of time. I can't walk very far. Well, what does that mean? What does that mean? You got to be very, very specific. And I'm not saying a form is going to make a difference, one way or the other, but you need to give the adjudicator some evidence, something that they can work with. But not very far and not very long, and I'm in terrible pain all the time, doesn't really say anything. So everything you should look at is through the lens of how your medical problems impact you potentially at a job. And I think that's really what you got to focus on.
Yeah, but appeal. Or have someone review it to see if it makes sense.
Yep. Yeah. And I'll tell you something else. I always also think that, when I'm looking at these forms, if at all possible, in my opinion, the adult function report or the disability report, these forms are available online. If you could type it in as opposed to handwrite it, I think that makes a difference. I mean, especially if you can't type and you have somebody else that did it for you, you make a note to that effect. I just think it's easier to read. I mean, Chad, as you just pointed out, these adjudicators are really pressed for time, and trying to read somebody's handwriting, is going to slow them down. If you can have it where it's easy for them, unless your handwriting is really, really neat, type it out. And even if you don't type it, this form completed by, claimant's spouse, because claimant can't type or is in too much pain or whatever, it just goes along. I think it helps. It makes everybody's life easier, in my opinion. Okay, so spine surgery, almost 56. That helps. Always better if you're over 50, and especially if you're over 55. 34 years of warehouse work, that says to me, got a long work history. That makes a difference. I've had judges tell me long work history makes a difference. You've had a fusion in your neck and a fusion in lumbar. You got two significant problems there. Now, the question, of course, is after these fusions, is there instability where the fusion was? Are you having, what they call adjacent segment disease, where the levels above and below the fusion are now weakened because of the extra pressure brought on them? Are you in pain management? Again, having surgery shows you had something significant. Where are you at post-surgery? I think that's something you would need to answer as well. But, again, your age, the work experience are really going to help, I think, big picture.
Oh, yeah, this is straight. We call this a straight take. We call this a straight take. When someone calls our office with these facts, it's a straight take. My intake person doesn't have to come to me to say, but understand, like, this person calls me as a straight take. It's usually because they lost. Like they lost initially, or they lost at recon. Right. And you're like, how did they lose? And I'm like, I mean, I don't know.
Yeah.
I mean, because they make bad decisions. I don't know what else to say.
Yeah,
I mean,
no, you're right. I mean, I think if somebody calls me and they're 57, 56, 57, they've got multiple surgeries. You're like, of course, that there's a pretty good chance you're going to win unless the surgery was unusually successful and they're completely restored to function. Even then, you may have a closed period. But yeah, I would agree. Those cases are ones
sure.
that you want.
Yeah, that
On
should
his
be
application, I put my restrictions, but the doctor's restrictions are different. And again, Social Security will rely on what the doctor said more so than what you say. I think what you say is relevant, but were the doctor's restrictions less restrictive than what you said? And that's a question I get a good deal. I'm sure you do as well, Chad. Somebody comes to you and says, "Well, my doctor doesn't want to get involved, or my doctor doesn't believe in the idea of disability. The doctor won't help me. What do I do?" And I always say, well, you may have to look at getting a different doctor. But what do you tell people in those situations?
I mean, start with, you see that with surgeons a lot because candidly, they don't honestly have the time. It's the biggest thing. Or you're not willing to pay them. So periodically, we do advance calls for doctor's letters, or the client can come up with it on their own. At one level, that's certainly that, you hear this, well, I'm not a disability doctor. Like, I guess they teach them in medical school that there's a special disability doctor that has some special, provision. I think that when your doctor, the other thing you get into is like, where is the doctor coming from? Like, if it's a workers' compensation doctor, understand they're not your friend, even if they did a good surgery. They really work for the insurance carrier that's providing your service. So, is it your own doctor? Is it a surgeon? Is it a neurosurgeon? Was it done, probably not here. Was it done from trauma? But, how is that relationship there? It can be tough though, because sometimes the doctor won't write a letter. So first thing we do when they won't write a letter is say, will you fill out a form? And we've got them. So you get them a form, a standard form. You can probably find them online if you Google it. Any lawyer worth their salt that does any of this already has them. You get them a form, because a lot of times they'll check the box for the form, or you have a conversation and ask that the conversation be transcribed. So you have a conversation with the doctor and say, look, I have to lift, I'm a warehouse worker. I have to lift 100 pounds occasionally throughout the day. Is it safe for me to lift 100 pounds in the next 12 months based on this fusion? They're going to say no, right? Because sometimes you can box the doctor in by saying, okay, I have to do this in my job. I don't think it's safe for me to do that. Do you think I should be able to do that following this surgery? And sometimes they'll still equivocate, and they'll step back and say, well, I don't know, different people can do this. And I used to hear the story. I was friends with a ortho surgeon. He's like, well, guys, paratroopers break their backs and they have surgery and go back to being paratroopers in 6 months all the time. And I'm like, well, it doesn't happen all the time. But okay, so you mean a 24-year-old who's in peak physical condition in the world has a 1-level fracture, they have a fusion, it is fixed, they have access as a 24-year-old to being able to heal very quickly? Yeah, okay, sure. Peyton Manning had a cervical fusion, he went back and played pro football. I get it. But that's not typical. So sometimes you just have to press the doctor to do it. Sometimes you can pay the doctor to do it. Sometimes you can get them to do a form when they won't do a letter. If that doesn't work, you can always back down doctors, back down from your surgeon to your family doctor, who often will be more helpful because they want you to keep seeing them for the next 22 years. Or you can sort of pin the doctor down on limitations and say, well, okay, you're not a disability doctor, I get that, but I have to, instead of letting them give you restrictions, you give them sort of the extreme components of your job that reasonably you're not going to be able to do. And typically they'll say you can't do that, because understand, if you can't do one component of that job as a warehouse worker, you probably can't do it. So if you can't meet the sitting, so look at posturals. If you can't meet the sitting, standing, walking, lifting, carrying, pushing, or pulling, 7 posturals. I'll say this again if I can remember them. Sit, stand, walk, lift, carry, push, pull. So there's going to be requirements of any job that have postural exertional limitations. And in a warehouse type environment, that's probably a heavy job. You're probably required to have to lift either 50 pounds frequently throughout the day, or maybe as much as 100 pounds occasionally throughout the day. Very, very rare. I mean, at least they're going to say you can't do it for 12 months. I mean, healing time for a lumbar fusion is 12 months. I mean, you're not going to be able to do that level of lifting. So sometimes you can outsmart the doctor and get them to sort of tell you what we used to go to doctors when we really needed their help. And we'd say, okay, what's the minimum amount of information they could tell us that would still accomplish what we need accomplished? And so you're looking for what is sort of no one in their right mind would say I could do this. You pin them on that point, you get them to put it in the record, and then there you go. You don't need a full letter. If you can't meet the lifting requirement of the job, you can't do it.
Yep.
So sometimes you just have to think. You have to think more, okay, it's nice if I can shoot the shotgun and I can get them to say I can't sit, stand, walk, lift, carry, push, pull, concentrate, and I'm going to miss work. And okay, that's great. We got the whole kitchen sink and you can't do any of those things and you're disabled. But don't miss the point that if you can't do one of the required job tasks in your situation, over 55 in a physically demanding job, you probably can't do your past work. You can't do your past work. The grid rules are going to kick in and you're probably going to win. So don't miss one really. I've had a lot of files that had 4,000 pages of medical records and I couldn't find a good record. I've had others that were 20 pages and I didn't need but one.
Yep.
We were going to win. And so,
and that shows the power of the grid rules. If you're over 55, you can't go to your past relevant work and it's unskilled or low end semi-skilled, you win. So like Chad says, all you have to show is you can't do, one component of that job, kneeling, stooping, lifting, whatever, standing for 6 hours, whatever it may be. And you win. And another point I would make is that surgeons, why it can be also difficult is if they're going to go on record to say that the surgery was not successful, they potentially are putting themselves at risk for a malpractice case. So they're not going to want to say that either. And again, surgeons don't want to say my surgery was not effective. So, you run into trouble. And that's another reason why sometimes the surgeon may not be the ideal person to, make the assessment for you as well.
We've had a lot of success over the years, though, in trying to find, okay, what is sort of just one. A lot of times you don't need but one peg to hang your hat on. You don't need but one. And a lot of times you can get the doctor to say that one thing. They don't want to write a letter. They don't want to do a letter. They don't want to fill out your form, but they're not going to say something that makes them look stupid either. So it's sort of this obvious limitation that you should have that you can disqualify you from the job.
Yeah.
You can, a lot of ways to skin a cat.
And if they do say something just ridiculous, like that a person without a fusion can lift 100 pounds 3 months later, then as the attorney, that would be something you would point out. You say to the judge, this makes no sense. Give this no weight. It makes no sense. And I think you'd have a pretty good argument. And I think on appeal, if the judge relied on that, on appeal, I think you'd have a good argument as well. Not that you want to go to appeal, but I think that's also the case. All right, Susan Schmidt from Noonan, Georgia. Have you ever been to Noonan, Georgia?
I don't think I've ever been to Noonan.
No, it's the south of Atlanta. I've been to Noonan. I used to do a good
near Peachtree City. In Peachtree City.
Yeah, not too far from Peachtree City.
Yeah,
and Noonan,
Georgia. I had a friend
Georgia.
from college from Peachtree City.
Say what now?
I had a friend from college from Peachtree City.
Okay, yeah, Peachtree City. Peachtree City is known. For those who don't know, Peachtree City is a city in the Atlanta area near the airport. A lot of pilots lived there, and what it was known for is that everybody had golf carts. They try to keep it, as limited, not as much driving, but people had a lot of golf carts. It was a fairly well-off community, again, a lot of pilots and so forth. But apparently,
is Valdosta down there too? We're doing a geography quiz.
Say again now.
Is Valdosta down there too?
No, Valdosta is way south. Valdosta is near the.
Oh, that's Florida. Right. Never mind. It's almost in Florida.
Yeah, it's almost in Florida.
Yeah, okay.
Peachtree City. Noonan is south of Atlanta, and I used to do some bankruptcy work, and in the Northern District of Georgia, where I did bankruptcy work. Atlanta, Rome, Noonan were all in the same district, different divisions. So I would go down to Noonan periodically. Anyway, neither here nor there. Nobody cares about my bankruptcy career, which I'm no longer doing. And Noonan, Georgia, with the Judge Drake down there, who passed away a couple of years ago. Nice guy. All right. Good evening from Noonan, Georgia. Good evening, Susan. I'm still in step 3 after applying 16 months ago. I went to both the mental and physical CE, last one 2 weeks ago, hoping to hear something. And again, here we get the fabled step 3. And my feeling is, and I think we've talked about this before, it doesn't mean a darn thing. I mean, step 3 just means, what is it? The step 1 is they haven't looked at it yet. Step 2 is they're starting to look at it. Step 3 is they're evaluating. I know there's definitions for these things, but there's no time limit on it. You could be in step 3, for a year and a half, right? So it just doesn't really mean a whole heck of a lot. I think it's really to make people feel like their actions being taken, even though there's probably not. But you're still waiting for a decision on your application. It's been 16 months. I would tell you.
She's at initial at 16 months.
That's what it seems like. I would say contact, Senator Ossoff or Senator Warnock here in Georgia and say 16 months is way, way too long.
So she had the mental CE 2 weeks ago. Is that right? Did I read that correctly?
Yeah.
It's crazy because in North Carolina, stuff is processing relatively quickly through DDS, and in South Carolina, it's a quagmire. You can't get a case through there. I mean, it's 12 to 18 months for initial. They sent you for CEs. It just slows the process down. I'm not saying you need to go usually, but it just slows the process down and just becomes an issue too. If they sent you for a CE, they're probably waiting for it to come back. I don't know. It's just frustrating. I don't have good answers for people. The government's inefficient. They need more employees, not less.
I'm just telling folks, once it's beyond 5 or 6 or 7 months, contact your U.S. Senator's office.
Yeah, I think we use 8 internally. Like if at 8, I think at 8 at any stage, you've exhausted what's reasonable. Call your congressman, see if they can do a congressional inquiry.
Correct.
If you have a number, you can call them. Sometimes they'll talk to you. If you've talked to the DDS examiner, sometimes you can just call them and say, "What are you waiting on?" Sometimes if you get them on the phone, they'll actually go ahead and make a decision. Sometimes it's just deny you and move it on. But.
Yeah, I don't know. I have such a hard time reaching them. These days that it's.
Oh yeah, no. I'm not saying you're likely. I'm just saying if you talk to them and you actually have an extension, and sometimes sometimes they do. I don't know.
I think
depends on who it is. There's not a lot of consistency with how DDS interacts.
Yeah, I think those days they're just so backlogged. I've called. Now we'll say every once in a while I'll call an adjudicator. They'll call back. They'll pick up, but I'd say that's 1 out of every 10. Most of the time I leave a message and never hear a word.
It is interesting that if you look at 16 months, that's way too long.
That's way too long.
But they just did a CE, so at least it's not.
Right.
Sometimes it's lost. People don't realize they lose stuff. It just disappears. And the reason it's 16 months is because actually you're not showing actively in the system, right. And that's when a congressional inquiry can be helpful. But if they did a CE 2 weeks ago, that's clearly not.
Yeah. But what problem? The other thing is that I've had situations where people will call me. It's been 2 years. And we'll reach out to Social Security. Oh, that case was denied. And the person never got the denial notice. And then you try to file for good cause and they turn it down. There's really no appeal.
They don't acknowledge us as attorneys and the case gets denied and we don't know. And the client just assumes we know, even though we tell them. By the way, if you have a lawyer, okay, if it's me or Jonathan, great. If it's not, still don't care. If you have a lawyer and you get a notice from Social Security, you call your lawyer. That's right. Because they are not obligated. Don't get me started on stupid Social Security policy. They're not actually it's not an error for them not to notify us. How that's possible, I've never understood. But if you get a notice from them, you call your lawyer and make sure your lawyer got the notice because
although I'm starting to see, I don't know if you're seeing it, but I'm starting to see more information coming through at using the ERE system where we're getting more information on the A and B sections of the files. I've seen a couple of decisions, administrative decisions come through at initial and recon. So I think we're getting more access to stuff, which is a good thing. Sure. But Chad's absolutely right. If you get a notice of denial, let your lawyer know. Email, call, fax, whatever you got to do. Usually we get notice of it, but there have been times when we don't. And, it's very hard to go back, it's 6-8 months later to go back and say, good cause, I didn't get I can submit an affidavit, I didn't get a notice, but if the claimant got it, it's going to be really hard to do very much with that. So, I think you want to just definitely keep things going. Okay. And Gia and Jose, or Joe, I see your note here where you're talking to SA, and I'll leave that between the two of you as far as different ideas there. Jen's my paralegal in Lincoln, Nebraska. I knew she was going to be on. So good evening, Jen. We've got Sandra Agzawala. Hope I pronounced that correctly. Sandra from Utah. Good to see you. Thank you for joining us. Hope you find this beneficial. Wayne. Wayne is 54, 7 months in process. My DDS examiner and I spoke about my own upcoming fusion. So you did actually speak to your adjudicator, which is good. I told her I was postponing it for a second opinion. She said we need documentation telling us why. So again, I think this is just part of what the examiners do, is they try to gather as much information as possible. When we may have emailed back and forth. I know I was emailing somebody about this. I'm not a big fan of letting the disability process dictate medical decisions. Make your medical decisions based on what's best for you. Don't delay a surgery because you think it may negatively affect your disability case. Do what's right for you medically. Let the chips fall as they may with disability. That's my take on it. So again,
it's also, and I can't quote it off the top of my head, but you're talking about a cervical, talking about a second opinion on a 2-level cervical fusion. There's, oh man, I'm sure we do federal. Well, Jonathan knows this, nobody else. We do federal appellate work in my office as well. And Aaron Dalton, who works for me, does all of our federal appeals. And I don't know if there's case law or there's actually a POMS that says, that relates to back surgeries and how not pursuing back surgery is not considered failure to follow prescribed treatment because of the unsure nature that the surgery will be successful. Does that sound right?
It's a ruling. Yeah, it's actually a ruling.
Yeah. There's a ruling.
Yeah, right. That
the short answer, Wayne, is really simple. It's a 2-level neck surgery, and there's no guarantee it's going to work. And I want to have another opinion before I make that big a decision. Oh, and by the way, I'm pretty sure there's a ruling that says that's not something you can use as a reason to deny me. So
yeah, and his point is we need documentation. You saying I'm uncomfortable with going through this invasive surgery without a second opinion is enough. I don't think you need, a doctor to say that you need a second opinion. You can say it. But I think that you need to show, I think the ruling says that you need to have a reason, a legitimate reason. And again, concern about a unfavorable outcome would be a legitimate reason. But yeah, that is not non-compliance. My point though is simply that, I've had people ask me, well, I'm scheduled for surgery, but I don't want to have the surgery before my my hearing. I wouldn't do that. I wouldn't go that far. But I think getting a second opinion for invasive surgery, I think is certainly a reasonable thing.
Very different than like people, for example, who have seizures, who can control their seizures with medication, and they say, well, I don't like how it makes me feel, which is much less tenuous than being able, like his scenario. There are certain scenarios where it's reasonable that you should take the medicine. It's reasonable that you should have the procedure, and not having it is really, there's not a valid reason not to do it. Unless you can't afford it, that's a different setup.
Different story. Yeah, I tend to, like, when somebody says, I've tried this medication and I have really bad side effects, I think that's a sufficient reason. But again, it needs to be documented, and you tell your doctor that, you have your own notes to that effect. But yeah, if it's a relatively mild, medication or something that's very effective that you choose not to do, that's a harder argument. But I think surgery by its own, look, even an epidural, which is pretty common. That's basically a pain medication injected in your spine to numb it. There's risk with epidurals. I mean, you could become paralyzed from it. So I've had people that don't want to have epidurals. Okay. You know, I understand that that's legitimate, I think, but again, you just need to make sure that's in the record there. All right. Carlil, welcome. I think, well, good. I don't know what I did good, Carlil, but I'll take I appreciate it. Trish Wade. Hello, Trish is another regular. We have DD Ramirez from another Utah person. Okay, we have two from Utah tonight, at least. Will my husband with osteoarthritis in his knees qualify without getting a lawyer? Okay, no way to answer that. How bad is your osteoarthritis? Is it knee replacement level? Is it, you know, mild to moderate? How old is he? Yeah, and then again, this is, you know, one of the things that and I'm not knocking, I'm just telling you that you know, the disability world, a diagnosis does not mean you're disabled or not. You don't win based on a diagnosis, but there's not enough information for me to tell. I'm sure Chad feels the same way.
No. I know that you don't have to have a lawyer to get like if you read the question literally, you don't have to have a lawyer to get disability, period. Yeah, I'm sure the question is my case bad enough that I should or shouldn't get a lawyer? And I think the answer to that is, I don't know. I think you know, a lot of people file initially by themselves. I mean, a lot of times people call us and they're just like, well, I don't know if I want to hire a lawyer or not. I'm like, well, whatever you do, go apply.
Yeah.
Like, if you want to hire us, we're here to help you. We file applications for people. We do that for people all the time. I have opinions about whether we do a better job than someone who's, you know, is my law firm that's done 20,000 of these in the last 24 years going to do a better job when you're doing it for the first time by yourself? So you've got one and you haven't even finished it yet, and we've done 20,000. Who do you think is going to do a better job? We're probably going to do a better job. Does that mean people have to hire a lawyer to file for application? No. A lot of times people call us and they're like, well, I don't know if I want to hire a lawyer. I don't want to pay a percentage of my back pay in the event that I get approved without a lawyer. And we tell them always the same thing. We'll go apply without one.
Yeah.
Go to the application, see what happens. I hope you win. If you do win, call us back, because I own a Medicare agency. We help people with Medicare, right? You know, and tell people about us who might need our help. I mean, but whether your husband specifically needs one, what's his age, what's his medical diagnosis, what are his medical symptoms, what medications are he on, do they have side effects, what was his past work, what exertional, I mean, there's a ton of questions you have to have answered. I mean, I think statistically lawyers win more cases than people without lawyers. That's a stat. I don't make that up because I'm a lawyer. Like, Social Security Administration tracks that people more likely to win their case if they have a lawyer than if they don't have a lawyer.
I think I always tell folks, what I tell people is, it doesn't offend me if somebody wants to file on their own. Go for it. And if you can, sure. But realize as well, you know, when you have a 5-month waiting period, you know, if your case does get approved early, you're probably not going to be paying that much anyway.
Oh yeah. I mean, like, if we get a really good case, I mean, we get sometimes people, when you get into this is well beyond it. This is like a lawyer talk about what cases do you take or not take.
Right.
Like, we take cases where I think people have a good faith. I can make a good faith argument that someone is disabled. Now, some people have a much stricter standard than that. We take a sort of a more broad standard. If I can make a good faith argument that you're disabled, and sometimes that means I need to see more records or not, then we're gonna represent you usually. But the reality is that if you have a good case, you may win with or without a lawyer, but you need to just apply and see. I mean, I don't know how else to.
Yeah, I think that right. If
we're
you
not
have
going to get upset. I mean, if you can win without a lawyer, great.
Yeah, I agree.
Wonderful.
Yeah, lots
of my clients should have won without a lawyer.
Yeah, look, well, that's right. It's just like, right. I think that's exactly right. Look, the bottom line is that, you know, we both, I know you have a video channel, you've got your podcast, and, you know, when somebody emails me and says, I won because of your videos, or I won because of your podcast, or whatever, I'm like, write me a nice review. You know, that's great. I mean, I admire that. That's awesome. And good for you. It doesn't bother me. There's plenty of work out there.
One of the things, though, if you are going to apply without a lawyer, okay, if you are going to apply without a lawyer, understand, like, you need to get the work history report completed very thoroughly and very accurately, because it has a huge impact on whether you win or not. You really need to have your medical records you need to make sure that all of your medical records are being noted to DDS, not just the ones you think matter because of the needs. Because the reality is let's say you think the needs are what qualify you for disability. A lot of times people call my office and they work with Tia, who does my intake. Tia's great. And, and she'll be like, well, all they wanted to talk about was this, but then I learned this. And this thing was way easier to get them on disability than the thing they were hyper focused on, which usually causes their pain or some, or sort of a, top of mind. But a lot of times they have another issue that actually makes them disabled if you understand the rules technically. And they haven't even thought about it because they sort of view the disability sort of through their own lens, but that lens is not objective. So when you use a lawyer or a good, there's non-attorney reps who do a great job too. When you use one of those folks, they're going to look at your case from a different perspective, objectively be able to look at the different components and different things that are going on with you to see, are there other arguments for you to be disabled? Can't answer the question. Certainly make sure you get all the documents in and do everything that you need to do. We win cases like we take good cases, and a lot of times the best cases we take, we don't make a fee, or it's negligible. It's a couple $100.
Right. No, I mean,
it wasn't really worth our time, but that's okay. Yeah.
Yeah. I mean, I've taken cases with people, that are compassionate allowance just because it's the right thing to do.
Someone calls my office with a compassionate allowance case that hasn't been filed yet. Like, we're going to file it for them. They're going to win, and we're not going to get paid, and we're perfectly okay with that.
Right.
I mean, that's not,
that's just part of what you do. It's just the right thing as a human being. Right. Yeah. I mean, one final point I do want to make about, because people ask, should they file on their own? One bit of advice I do give them is, or a couple of things. One is, and you kind of touched on this, focus on the conditions where there's objective evidence, where there's an MRI, a CT, X-ray, something, as opposed to something that's more subjective, because that's more Social Security's language. The second thing is, I think people sometimes, in my experience, have a habit of putting in their 15 medical problems. They've got diabetes, they've got depression, they've got, high blood pressure, they've got high cholesterol. I think I think it's, in my opinion, focus on the top 2, 3, maybe 4 conditions. The other stuff, I think it just starts to become background noise when you have too many conditions. Maybe there's rare situations where somebody legitimately has 10, major things wrong with them. But, I think, you got to be careful about, making it seem like you're saying everything is wrong with me. I can't do anything at all, things like that. So I would just say that's one bit of advice I tell somebody when they're doing it on their own. But if you want to do it on your own, go for it. All right, Wayne, and we talked about this, and I think he kind of said about the reason why he might not want to have a surgery, that the doctor noted that he has legitimate fear of surgery, seeking a second opinion. I think that would be more than sufficient for the documentation that the adjudicator wants. And again, I think even a statement from you on Form 795, that I've been advised that I need a double fusion in the cervical spine. I'm, after researching it, I'm very concerned about, I talked to my doctor, very concerned about the risk of paralysis or, loss of function. And so I'm choosing to get a second opinion about it. I think that's more than enough to satisfy what the ruling says. Hello, happy to see you again. And that's one of my clients. Good to see you there. Lulu says, if you're partially approved, can you get monthly payments while you appeal your onset date? Okay, this is it's a great question. So the scenario would be this. Social Security, the administrative level, approves you, but they change the onset date. So let's say you alleged you became disabled in March of 2023. They approve you in June of 25, but they use January 25 as your onset date. And this is the administrative level. You appeal that. Will you get benefits while you appeal? What's your take on that?
Typically, yeah.
And well, there are two issues here. One is, you would get benefits. The risk is that if you end up losing, you would be
create overpayment.
Right?
You're going to get paid in the interim. I mean, in most cases.
When I tell people
that's screwed up, which happens as well.
Yeah, what I tell people, well, I mean, my feeling on it is, if Social Security at the administrative level found you disabled at some date, is it really likely that a judge is going to down the road find you not disabled? Now, there are certain judges, one in particular I'm thinking of in Charleston, South Carolina, that if you get in front of her, you got a big problem.
Yeah, this is an interesting scenario too, where if you look at, I mean, this wasn't the question, but I think this is, hopefully helpful. I mean, we get this happen a lot. We file an application for someone, they get approved, partially favorable decision, and they want us to tell them whether they should appeal or not. The answer is the perfect lawyer answer, which is, well, it just depends, right? Are you appealing because you lost 3 or 4 or 5 months of benefits? I don't think that's very smart. I think the risk associated with losing a case at a hearing, especially when you don't know who the judge is going to be,
right,
is relatively high. And if they gutted your case, and they took 3 or 4 years of benefits from you, and it's $50, $60, $70, $80, $100,000. I mean, that's a different assessment. I mean, I get a lot of people who are mad about the modification, and I look at it, and in my opinion, it's negligible time. 3, 4, 5, 6 months, 8 months, even. It's $5,000, $6,000, $7,000, which I'm not marginalizing that being a lot of money, but in the big picture of winning your case and having your future benefits and having the Medicare that comes with it and doing those things, like, that just doesn't make a lot of sense. Now, one of the things we'll do too, you gotta be a little careful with this, is you can't appeal your case till you get to the hearing, request a hearing, and then withdraw your request for hearing once you figure out who the judge is. Now, the risk in that is that technically the judge has to grant the dismissal, which means if you appeal and you get a judge who isn't very favorable, they say they have a 20% approval rating, 15% approval rating. Those folks exist.
Oh, yeah.
And you're going to be at the hearing level, and that judge has to grant your request to withdraw your appeal and accept the lower level decision. The good news is, by and large, they're going to do that. Now, obviously, I can't promise anybody anything's going to happen, but typically a judge, even in my experience, even the worst judges are by and large not going to have to do an additional hearing and write an additional decision when they can just basically grant
the withdrawal. But I would agree with you. If the difference you're giving up is less than $10,000 is kind of my standard.
Yeah.
I think you got to really think long and hard about it. If it's 30 or 40,000, yeah. And I've had everyone that I've appealed to try to recover that 30 or 40,000, we've won. But it could happen the other way, and you got to take that risk. And you can bankrupt on it, of course. But imagine how frustrating it would be to know that they approved you at one, Social Security administrative level approves you. You go through and you get to a judge who finds that you're not disabled at all, and now you not only don't get ongoing benefits, but they say you got to pay us back all the money we've paid you. That's the risk that you run. Is it a high risk? No, but it is a risk. And so again, for less than $10,000, probably not worth the risk. But and of course, if the change in onset date takes you out of SSDI territory, your date last insured is run, you have no choice. But if it's just a matter of change, of a few months, then I wouldn't have. In fact, I don't know if you're seeing this. I'm seeing more and more administrative decisions where they are changing the onset date. That seems to be the tactic where they just let's just chop off, a year and a half of benefit. We don't have to pay this person, so it puts you in that very awkward situation. So, but that's what they do. And especially if you are, let's say you're applying and your onset date, you are, let's just pick a number, 53 years and 11 months old. And by the time you get close to a hearing, you'll be 55. There's a pretty good likelihood they're going to find you disabled at age 55, not pay you that 13 or 14 months. So, that when I talk to somebody and, they're at that sort of that cusp of that next level 49 to 50, 54 to 55, sometimes I say you might as well just try to work, until you've hit that next age threshold, because they're probably not going to pay you anyway. So just be aware of that too. That's a trend I've definitely noticed. Okay. Jim says, how can SSA constantly warn us about overpayment when they have all the factual information on our earnings at our disposal? Seems like they dropped the ball. So I'm guessing what you're talking about would be if you've been approved, and then they send you a letter 3 years down the road saying you have exhausted your trial work period, you've been working over SGA, you owe us all this money back. And the answer, Jim, is Social Security's inefficiency. And I've talked about this a lot on this live stream, and that you would think that they would sort of know in real time that there's potentially an issue, but they don't tell you. And there's no place to find out. You've got to keep your own records. And you have these special rules for the trial work period. Then after the trial work period, you got to deal with the SGA, which changes every year. It gets really, really confusing. So, they pretty much put the burden on you to figure out if you're going to be in overpay status, and they may not tell you for 3 or 4 years. And Chet, I'm sure you've had this happen to you.
Yeah, we get this scenario too, where we had a case. I don't know what day of the week it is. What is it? Wednesday? Okay, one Monday. All right, wasn't yesterday, so it had to be Monday because we didn't work this weekend. And clients calling in about work. They've been working. They got a notice of overpayment, and we had this conversation where it's really confusing, because people, when you have a 9-month trial work period, and literally in that 9 months you can make pretty much whatever you want to make, but it's not SGA that triggers the work period. It's work for services, which is a different number. So people call Social Security and they say, well, how much can I make? And they tell them SGA. And what happens is, so people work under SGA and they work over work for services, and they burn their work period, and then they get they earn SGA, and boom, they lose their benefits. And they're like, well, I wasn't under SGA. I was under SGA every month, and that wasn't actually the test the whole time. It was work for services. And so I think part of the reason that there's confusion is sometimes it's not that they dropped the ball. You didn't understand I'm not saying this is your situation, Jim, but they didn't understand. You didn't understand the rules.
Right.
You actually were making amount of money that was ticking your trial work period away, even though it was under SGA, and you didn't know it. And then you finally have a month where you go over, heaven forbid, your pay periods overlap, and you end up with.
You have a biweekly or 3 pay periods in a month.
That month, and your money goes above SGA, or SGA changed, and you were still thinking it was, $1,400, but it was really $1,600 or whatever the change was, and you sort of get confused. So sometimes it's that you report the income, and there's a huge delay in them actually telling you what's going on. Sometimes, though, the error is actually yours, because you were actually making too much money and you didn't know you were, because you didn't understand the rules, which is why in all of our exit interviews with our clients, when they get approved, we say, look, you may decide you want to go back to work. I don't ever discourage people from going back to work, but you need to call us if you go back to work, so we can make sure you understand the rules, so that you don't wake up with a month 10 surprise that you weren't expecting and end up, had a crazy case once. I had a really high level nurse. She was a nuclear medicine nurse, was very, very skilled, very, very smart, was offered an opportunity. She thought she understood the rules. She misinterpreted the trial work period rule. She had an opportunity to go back and work for about 9 months. And make a lot of money. I think she was making like $6,000 a month, $6,000 or $7,000 a month. I mean, it was enough money that they needed the money, and she was able to. The doctor was really accommodating her, but she misunderstood the rules, and then they paid her incorrectly, and they actually got to pay in the wrong month. And so she called me, and she's like, "Well, I just figured I could do it on my own. I could figure it out." And I think we fought her case on appeal for 2.5 years before we finally, goodness gracious, it was Greensboro back in the day. We drew a really good judge, and he agreed with our interpretation of the trial work period rule, and actually gave her gave her benefits back. She was able to get back on. They had to get back on benefits, but so sometimes they just drop the ball because they're inefficient and it takes them forever to find the information. And their position is you have an obligation to tell us what it is, and you know, sort of ignorance of the rules, not a defense to them.
Right. And the fact that I think what Jim is getting at is, will they have access to these records, but not apparently in real time. I guess they get them from the IRS and they get them after the fact, and they look at it. And again, you know, they're getting yearly numbers as opposed to we got to deal with it on a month by month basis. It would really be nice if there was some sort of a real time, you know, portal where you could go and put your information in, but that just doesn't exist. So,
well, even if they had the information in real time, someone actually has to look at it.
Yeah.
Which doesn't happen either.
Right.
You know?
Exactly. I know with all the shortage.
They're tough. I hate overpayment cases. They're really tough.
They're very hard. Look, and it's very hard to, you know, to hire an attorney because, you know, if there's no, you know, there may not be any past due benefits. So, you know, typically you got to pay your attorney up front. So that's a really difficult thing. All right. Lulu says, how long is appealing onset? Again, if you appeal the onset date, you know, you get an approval at initial recon. It's just like going to a regular hearing. It could be, you know, 2 years before you get in front of the judge.
That's a fair guess.
All right. Rebecca says, I applied for disabled widows benefits. I'm 58. My husband passed last April. I had Social Security send me to get a CDR, which I don't understand. Why would this affect my own SSDI? I don't know. I mean, the only thing I'm thinking is that, you know, the disabled widow benefit might give you a higher benefit, but if you had your own, you know, disability case, you know, the CDR might be related to your case and have nothing to do with the disabled widows benefit application. So I'm not sure that the two are related other than coincidental. But there's I don't think that applying for disabled widows benefits would trigger a CDR.
Well, I mean, at 60, you get them regardless. So it's not like, I mean, 60, you're going to pick the benefits up disabled or not. So it's not even going to matter in years. I don't know. I don't know. Sometimes I think when changes happen in the system, it just triggers stuff. But technically supposed to do a CDR every 7 years. You know, they stopped doing them during COVID. A lot of them have been picked up. We've seen a bunch of CDRs in our office in the last year and a half as they've started to do them again. I mean,
do you see many CDRs for people over 50 or 55?
No,
I don't think so either.
Not a lot. Rare. I'm over 55. I can't.
Pretty rare.
I had one a couple years ago. Crazy set of facts. Won't bore you with those, but I mean, yeah, I don't know. It's probably just that hee-haw song goes. If it weren't for bad luck, you'd have no luck at all.
Yep.
Well, I would just say it's probably coincidental.
Yeah, I think
it could be related some way I don't quite understand if I knew more facts, but I would say it's probably coincidental.
Probably coincidental. I think so.
But
too.
it's CDR. But the CDR at 58 is usually not a really difficult thing, unless I don't know, unless you had like
significant improvement.
Resolved.
Yep. All right. Rebecca says, thank you. You're welcome, Rebecca. Sandra from Utah. Have you seen many people that have long COVID as a secondary? How much success? What is your take, Chad, on long COVID cases?
I think it's real.
Mm-hmm. I know it's real. I don't think it's real.
I don't. You gotta remember, everything at Social Security is not. There's whole groups of people who don't think things are real. I think it's real. I think it's a real problem. I think when I see success in the long COVID context is what you had were people who had pretty significant underlying pulmonary problems to start with. With long COVID, there's sort of a range of symptoms that people have that aren't necessarily pulmonary related, and they want to say it's long COVID, fatigue, and maybe dizziness or
mental confusion.
Just sort of, kind of like fibro fog. They can't quite put it all together. I don't think that's very good. I just think it's too subjective. It's too hard to tie where the science is now. But I mean, anecdotally, I had never been sick till I had COVID. I was very, very, very sick. I was in bed like 9 days, had to go on steroids and different things, and I was healthy. And I think I've had to be on steroids 3 or 4 times since I had that. I don't think I have long COVID, but clearly my lungs were affected such that I have a little difficulty getting over stuff that I didn't have before. I like to think how old am I? I'm 51. I like to think at 51, I'm probably not old enough that like it's necessarily age related. So what we see is when we have long COVID diagnosis, and there's an underlying set of pulmonary
comorbidities,
that existed prior, could be heart, some, but usually it's a breathing. Like we see what we find are people who had breathing problems, and now what they say is, I just can't, I stay sick. I can't get better. I can't get over it. I think those have a lot of teeth, and I think they're good cases, and I think it's a strong argument that we make. And I think as we understand more, as they start to release science that deals with sort of long COVID, and they can study it, as well as we get some information to sort of make it more, more mainstream or more objective, where you can tie it. I think it's a thing we're going to see more of. For us, if it's not pulmonary, I'm not probably going to deal with it very much. But you have people who were on, they were put on ventilators, they had extended hospitalizations, and they just haven't recovered. They just can't get back to where they were. It's not that you don't argue it. I think you can argue it secondary to that and say, this is sort of the catalyst or the exacerbating factor that led them to go from not being disabled to now being unable to, maybe sustain the stamina necessary to do the walking in their job, or it creates absenteeism because they're sick and they can't get better and they just miss too much work.
Yeah, I would agree. I think that I've seen people that were, maybe not the healthiest, but were able to work, but then COVID comes along and all the problems they have now become magnified. I also found that the pulmonary, the breathing issues are the ones that seem to be most, move the meter the most with Social Security, as would be cardiac issues. People have damage to their heart. That seems to be what Social Security thinks is the most significant. I've had a couple where I had one gentleman, I've talked about him a little bit. The vaccine caused a real significant problem.
Oh, yeah.
And he had specialized treatments. So, if you have what you think to be long COVID, I suspect that there are a number of these medical doctors, clinics that are popping up that deal with that. And if you can get to one of these, kind of like with the migraine, specialist, somebody who deals with long COVID, and that person can really pin down the symptoms and relate it to the COVID, that's going to make your case stronger.
If it's breathing, your pulmonologist is going to, it's my experience is if it's a breathing related issue, your pulmonologist is typically working with a pretty high level understanding of how those two may interact, and can give some opinion on that, or at least some notes on it. That's not. I think in the pulmonary space, I think there's a lot of acceptance just because there were so many respiratory issues associated with COVID.
Yeah. But look, I have a buddy of mine who's otherwise pretty healthy. He's in his 60s, but he's had COVID 3 or 4 times, and to this day, we play tennis. He can't play when it gets hot. I mean, in the summertime, he will not play. After say, he'll latest to start would be 9 o'clock in the morning. If he tries to start at 1 o'clock, he literally can't finish. And he never had that problem before. But post COVID, there's just some sort of a permanent breathing issue. And again, this wouldn't be disabling for him, but it's definitely something that is noticeable.
It's real limitation, especially if you have
limitation, right?
With it. Yeah, for sure.
Absolutely. All right. So DD was the person asked about her husband. Now, a little more information is coming in. He's 43, and the doctor is not suggesting total knee replacement. So again, the problem right there is being 43 is problematic. That's pretty young for Social Security. It's really hard to win if you're under 50. The arthritis is not at a level where he needs a knee replacement.
Yeah.
That's a tough case. That's my take.
But on the other side of that, to play devil's advocate, sometimes the knee problem at 43 is severe enough, but they don't want to do the surgery because they're afraid if they do the surgery, life expectancy is only 20 years.
or not life expectancy for the person, but that the knee replacement.
Not life expectancy, the knee
yeah.
replacement is only 20 years. So
right.
now they're saying, well, we don't know if we want to be able to do another one at 60, and they're trying to get you to delay
right.
the knee replacement because of the time frame and the expected
duration of the
knee replacement itself. So sometimes you can argue, my doctor doesn't want to. Now we're on the other side of this medical treatment question, right, that we had earlier. Now it's my doctor saying he doesn't want to do the surgery, but the symptoms are actually severe enough to justify it. Therefore, you could make the argument they're severe enough to either certainly preclude standing and walking. The problem is now you got sedentary jobs, so you got to get out of a sitting job, even though sometimes sitting is more painful when you have a knee problem
yep.
at the level for replacement than standing. And then you get into these hybrids, sit-stand options and all those junk jobs that I don't think exist. But you end up with a scenario where you could argue that successfully, but now we're back to what's the objective? What's the objective? What's the MRI of that knee show?
Right.
What's the X-ray of that knee show? How much degradation is there in the joint? Are you bone on bone? What is your level of pain? How is that pain being treated? What are the side effects of the medication? Because it could be that you have a very severe knee. The doctor wants to wait 5-7 years to get you to 50. The solution to that is now you're on pain medicine. The side effects of the pain medicine are what make you disabled,
right.
not the actual knee itself.
Yeah.
I mean, it's not that you can't make the argument, but it's certainly a heck of a lot easier to make that argument.
Yeah. And is it both knees or one knee? But that's actually a very good point, is that if you are essentially a knee replacement candidate, but because of your age, the doctor doesn't want to do it, you're in limbo because you need one, but the doctor doesn't want to do it because you're quote unquote too young.
This is knee, but you really see this with hips, because once you do a hip replacement, at best you have one more because they can't actually connect the hip replacement. And so, like, if you have to have, by the time you get to the third hip replacement, you're in a wheelchair almost always. So even though the question is about knees, the same logic applies, and I see it in hips. You see it with hips. I mean, any of your major joints, any of your major joint replacement. You see it with shoulders as well. I mean, you have a major joint replacement, they want to delay it because there is a life cycle of that replacement that you may expire, that you could exceed if you do it too early. So
I think you're absolutely with hips. That does make sense, because I think that's one where there's only so many they can do, and
for sure,
it kind of wears away.
Yeah.
All right. Lisa says, is there such thing as substance abuse disorder? Why isn't I considered in favorable decisions? Well, the simple answer is that Social Security has rules that say that if they see substance abuse as what they call material contributing factor to your disability, you're not eligible for benefits. So even though, people have, an addiction disease, which it really can be a disease, that is just not going to, Social Security just won't pay you. I mean, there's no other way to put it. They're just not going to pay you. The only time they would be if you have organ damage. I had a couple of clients over the years who were alcoholics and have been alcoholics for 30 or 40 years, and their liver was, so damaged that even if they stop tomorrow, it's not going to get any better. But otherwise, if you're, an active user of substances, the assumption is if you stopped, you'd be able to return to work, even though, I suspect, and, that it's really, really hard, if you're on whatever substance it is, very, very difficult to get off of it.
And we look at those like there's a question like you talk about the liver. You also see it with alcohol-induced dementia. You see it with COPD, with smoking, where the lungs have reached a point where they wouldn't improve theoretically even if you stop the abuse. What we typically do, though, is we don't, like, let's say you call our office with that scenario. I keep saying Tia because Tia's my intake person currently. She's really smart. Tia's going to dig below that and say, okay, why do you have substance abuse issues? Because very frequently what you see are substance abuse issues are tied to underlying mental disorders. Now, sometimes now we get into this chicken and egg question. Well, did the substance abuse come as a result of the mental health, or did the mental health cause the substance abuse? The point, though, is they're often an associated impairment that you can discuss and explore that actually would be disabling, which also leads to a second level often of, well, why do you have the depression or anxiety to start with? And so I know historically what you'll find is very often what we find is oftentimes significant history of abuse, physical, emotional, sexual abuse that led to anxiety and or depressive disorder, which led to substance abuse. And now all of a sudden, what we're doing is saying, okay, just put this aside. There are ways to assess and review drug and alcohol abuse inside the system. But let's put this aside for a second and say, if you weren't using substances, would you be disabled? And because that's the format. In fact, we do appellate work because the judges will get this backwards all the time. And we have a whole set of appeals that we do just when they screw this issue up. But the reality is that often there's an underlying mental health problem that's often tied to another set of deeper issues. So what you can do is you can take a case where initially you think the reaction of the judge would be drug abuse or denial, where actually they were the victim of abuse and developed mental health problems. And candidly, this is just how they ended up coping with them. And so in that scenario, often you can make a good argument that the person is disabled, especially if they've been in mental health treatment. You can document the abuse and you can sort of lay that foundation, but you have to lay it separate and independent of the substance abuse, because the substance abuse in and of itself can't be the basis for your disability.
Yeah, but it's, and let me just, my opinion at least, I think it's really difficult to unwind those.
Oh yeah, I'm not saying it's easy. I think
because you got to prove that you have an underlying mental health condition that would exist at a disabling level. Even with, and if that person's been using substances for 10 years, it's hard to unwind that and untangle that. But
and then you're in a case by case specific. So if you just have someone who has some general anxiety and they sort of started using marijuana and that led to something else, okay, that's one thing. But sometimes you have people who are have severe PTSD, or you have vets who have severe PTSD, or sometimes you have people with schizoaffective disorder. So it's really sort of case by case. I agree with you. I mean, they're always tough. That goes without saying. Those cases are always tough. And that's why, in our case, those are very fact specific about whether we think we can get involved and get them help or not.
Okay. All right. Susie B. Again, a very good question. 61 years old, recently approved for SSDI, thinking about taking an online class. Will this be a problem or trigger a CDR? How would you answer that?
I would say most likely not. It's highly unlikely that educational classes are going to trigger a CDR at 61. I don't know what the internal procedure is at 61. I don't think I've ever seen a CDR of anyone over 60, unless maybe they had I guess you could have a very specific sort of cancer diagnosis or something that was treated, and the judge ordered a CDR, and then they actually picked it up and did it. The issue though is if you're able to take classes, are you able to work? That's sort of a foundational issue we see in cases where, if you're able to do school, why can you not work? But at 61, I mean, that wouldn't give me a lot of,
especially if it's one class.
I mean, anything could happen, but that wouldn't be a red flag for me.
Right. If you're taking one class, I don't think so. If you're taking, 5 classes and you're in class online, 8 hours a day. And they give you
you're not required to report that. It's not like working. You're not required to report to the Social Security Administration that you're taking classes.
Right.
So, like I said, that wouldn't give me a lot of concern. I mean, there's always concern to CDR. If you get a CDR, then everything's up for everything's on the table if you're in an actual CDR. But
what if Susie was 41 instead of 61?
I would want to know why she's in the class. I don't know how many hours she's taking, what her intentions are. Does she plan to try to return to work? How are you paying for it? Where are you doing it? What are the classes? Is it online? Is it online knitting? Is it financial accounting? I mean, these are very different. These are very sort of different routes you could be taking. That would give me a lot more concern than 61.
Yeah.
Same issue but the CDRs, once the CDR started, everything's on the table because they're reevaluating your whole life.
Right.
In terms of triggering it, I don't think school in and of itself triggers CDRs unless
Right. But
I mean, you had the scenario where you could be investigated. I mean, there are investigators that investigate people on Social Security. They could watch you get up, and if by some chance you drew the short straw and somehow you became the subject of an investigation, that's a very different type of scenario. But once again,
rare.
It's just rare. Yeah.
Yeah. But again, the situation. Let's say you had a long form CDR, and they request medical records, and the medical records talk about that Susie is in school. That's where you start to run and have to explain that. You get an adjudicator.
Yeah, I think if you're in a CDR, understand it's going to be something you're going to have to deal with. So if you're going to do it, and you might be in a CDR, 41-year-old's probably going to have a CDR.
Right.
61-year-old's probably not going to have a CDR.
That's exactly. I think the age is the real factor there.
Yeah, for sure.
I would agree. And look, I mean, I don't think Social Security expects people while they're applying or even after they've been approved to sit in a room and look at the walls. I mean,
no, that's not the definition. I mean, that's definitionally not what disability is.
Right. So you can do, and I think keep your mind active. Yeah. But there's a difference between monitoring a recent modern history class versus taking some 3 or 4 programming classes in C++ or something like that. Different entirely.
If you're younger too, the question is, are you taking it pursuing a degree?
Mm-hmm.
Are you auditing a class from Hillsdale College, which I've got a daughter that's on my mind because I have a daughter my daughter has a friend who goes there, and she was just talking about it. They have a bunch of online classes about the Constitution. If you want to take them, you're not pursuing a degree. They're really they're different than sort of taking an online documentary.
Yeah, just to keep your mind active. Okay.
Yeah, sure.
All right. CC, middle of applying for disability, had cervical neck infusion. You mean fusion, I'm guessing. What do you think? 43-year-old female with about 36 credits. I mean, I assume you have enough credits. If you have 20 credits in the last 40 quarters, you should be fine. Cervical fusion, again, 43 is the issue. You're young for Social Security purposes, and simply having a fusion doesn't make you disabled. Now, if you've been suffering and really not being able to turn your head for the last 2 or 3 years, you got an argument for a closed period. If you have the fusion's not successful, but I would just tell you the 43 is going to be the thing that's going to give me pause, just because you're young, and I just think it'll make it really difficult.
Here's my sort of 20-year experience assessment. I think cervical pain is often as or more severe than lumbar pain, but in the system, it's not given as much weight. Cervical fusion is not going to be given the level of weight towards being disabling by the average ALJ. We tell people with cervical fusions all the time, it's not unreasonable that you're going to be out of work for 12 months, even though the standard recovery time for a fusion is not as long as it is for a cervical fusion is not as long as it is for a lumbar fusion. But, if you're out of work for 12 months, it's very reasonable for you to be able to get a closed period for that cervical fusion. Cervical fusions become disabling, in my opinion, in a number of scenarios. One, when they're a result of trauma and traumatic injury. You have a car accident and you actually have you have a completely crushed disc and another disc, and you got a multi-level fusion, and you end up with severe range of motion issues and pain. And so a lot of times with the cervical case, to win a cervical case with ongoing benefits, it's really going to be tied to not the fusion itself and exertional or postural limitations, how you can hold your head or look or turn, because almost all of those are going to be accommodated in it for someone under 50 in some type of job. The question will be, do you have residuals that preclude work? That is, did you have such a cervical injury that you end up with permanent damage in your arm or your hand?
Right.
Do you have permanent pain? Did the cervical injury come as a result of head trauma, or actually you have a TBI, a traumatic brain injury, that's going to be the issue? So cervical fusions, in my opinion, are very difficult to win on people under 50. They're not difficult to win closed periods. If you get ongoing disability from a cervical fusion, it's almost always going to be secondary to a related issue to the cervical fusion, either some level of numbness, some level of pain, some level of limitation from whatever happened that caused the fusion.
Yeah, well, a lot of times you look for
sometimes a headache. And sometimes you get headache cases.
headache. I was going to say headaches.
Yeah.
And you also a lot of times
once again, that's not the fusion that makes you disabled.
Right, it's the subsequent, or you may have the neuropathy in your arms, and you have a nerve conduction study that shows carpal tunnel or something because of all that. Yeah, absolutely. Yeah. All right, so Joe tells me I have a nice haircut. I appreciate that. I did get a haircut. See, this is what happens on these live streams, Chad. People,
beautiful.
They tell me about my haircut because the last week I didn't have a haircut, so I looked terrible, I thought, and so I got a nice haircut. And
we were traveling for my last 4 podcasts. We were traveling to Wisconsin with my son, and so I didn't have my razor, and so I didn't shave. So I was looking at videos for the ones that are coming out like 2 weeks from now. I was like, I have this terrible beard. I hadn't shaved today, but I have like this terrible beard, and I'm sure like the comments of the podcast are going to be nice beard.
Nice beard, that's right. Well, and it's not my knees, Joe. My knees, not that they're great, but I don't have any problem with I'm still able to play tennis. I'm not quite at the pickleball. I mean, pickleball is fine and it's very competitive, but I'm a tennis player at this point. But but I appreciate the comment on my haircut because I did need one. And actually, it took me, not that anybody cares, but I have what they call crowns where my hair goes the other way. So it takes me a while. I had to find somebody that really knows how to cut it because otherwise, if they cut it too short, it just sticks up. So
we got a haircut tomorrow. My nephew's getting married this weekend, so I'm going.
Very good.
We moved to North Carolina last June, and I only found someone to cut my hair last month. So I had 10.5 months of bad haircuts.
Really yeah. No, I know. When I was a little kid, my dad used to take me to his barber. My dad would go every 2 weeks, and it was really hit or miss. Anyway, all right. Trip Weatherspoon, have confident my reconsideration. Again, tip, I can't without. I mean, the odds of reconsideration approval in general are about 15, 16%.
13%.
Something like that. It's very low. Yeah. So that's not where I would put
reconsideration is a stage that I'm convinced is in the process to just get people to quit.
Yeah, I think you're right. I think you're probably right.
Yeah.
All right. RD asks, is an interstitial cystitis the same as chronic bladder pelvic pain in the SSA blue book? It's similar. I don't know that it's exactly the same, but obviously interstitial cystitis is a condition where urination is very, very painful. It's usually frequent urination. Again, very painful. So it's not necessarily pelvic pain, it's more bladder pain. So it's sort of a different diagnosis, but similar. And obviously this has more to do with just the discomfort with urination and inability to hold a lot of urine and things like that. But it can be, I've had pretty good luck with IC cases. I don't know if you see many of them.
Yeah, I mean, I never forget. I had a friend, her mom had it. One of the first cases I did, like, I don't know, 04, 05. I mean, so I had no idea what it was at the time. I think in interstitial cystitis cases where you have the right level of treatment, you're on the right medications, you have the frequency of urination, it's like a headache case. You need to document it. Like you need to document because frequent urination will destroy your ability to perform competitive employment. Just like
and frequent being once an hour or more often.
Yeah, I mean or some it could be. I mean, it's sometimes
90 minutes, right?
But usually interstitial cystitis case, they're going to go to the bathroom all the time. Like it's going to be 15,
20-30 minutes, right?
A day or something. So you need to document it. I mean, I would not consider that the same as a bladder pelvic pain diagnosis. I mean, interstitial cystitis is a very specific diagnosis you're going to from the urologist. Bladder pelvic pain is sort of like having, generic gastritis. Like it affects you. It certainly can be disabling. It's sort of like I don't know what to call it. I mean, that's how I view it. It's like I don't really know what to call it. Doesn't mean it's not disabling. It's just saying I would say that's not the same as interstitial.
I don't think it's the same thing.
Which is an actual diagnosis. Urologist.
Yeah. And interstitial cystitis, a lot of times they'll do. I mean, the procedures they do to treat it are almost kind of barbaric. Where they'll fill the bladder scrapes
and
it's pretty uncomfortable. I mean, I've had several clients with it, and I think it is usually quite disabling, in my opinion. If it's not, because it's hard to treat. Really,
You got to document it. You got to go to the doctor. You got to
Yeah.
document. You got to document the frequency of the urination, and
Yeah.
Sure.
All right. Now, Zippy here has Meniere's disease. That's a tough one. I don't know if you've had much success with those. Those are just tough.
I don't like those cases. They had the table tilt test and all of those issues as well.
Yeah.
I mean, if you've had all that done.
Yeah. I mean, it looks like she's been approved. Has to wear I don't know what is a HIMPIT? I don't know what a HIMPIT is.
I mean, I think the chances of you having a CDR are somewhere between slim and none.
It's 60. Yes, it's 60.
And I would say somewhere between slim and none. I wouldn't be worried about having a CDR.
Yeah. Yeah. All right. If letters come from Office of Temporary and Disability Insurance, I'm not sure what the question is there. Maybe there's another part to that. Okay. Matt F is turning 50 on Sunday. So happy birthday, Matt F. Past work was a desk job, have neuropathy, can't sit for more than an hour, not needing a break to elevate, have chronic fatigue, and have fallen 10 times in the past year. Again, this is a tough one because you're turning 50. So now you get into the grid rules as of 50 if you're limited to sedentary. Sitting for an hour is a decent amount of time. I mean, again, Chad alluded to this before. There are jobs that Social Security claims exist called sit-stand jobs where you can do them sitting or standing. Now, you talk about needing a break to elevate your legs. If that's documented, if you've got to elevate your legs every hour for 10 minutes, that's problematic.
If your doctor says you need to do that, if you just say it, it's not near as persuasive.
Right. And
it may still be true. It's just not as persuasive.
Right. You got doctors say, and chronic fatigue, again, kind of a hard one to pin down because, that's very subjective. And a lot of people.
This is a great case too, though. Like, in a case like this, what I'm going to want to do is you're going to want to do two things. You want to look at, okay, what was the desk job?
Mm-hmm.
Okay, what level of skill does that job have? And how does the mental related issues, the fatigue, how are those possibly removing your ability to meet the skill requirements of the job? Because because you just got to get them out of the job and get them limited to sedentary to win. So, but what is actually the physical issue? So in my mind, like in a case like this, you're going to come in and sort of say, okay, you're throwing everything at me. I'm not saying you're doing that. I'm just saying this is what happens. You come in, you're like, well, I've got neuropathy and I've got chronic fatigue and I've got degenerative disc disease and I got PTSD and I can't stand up and I fall and my feet swell, and it's like, you're like, whoa, let's figure out what physically prevents you from doing the job. Let's figure out what makes it difficult to meet the emotional, mental demands of the job. And let's figure out the best way to hang our hat on an objective piece of evidence that sort of, ideally takes out each one, and then you use the grid rules. And that's a case that you can, you're going to be able to win pretty easily if you can attach the limitation to objective evidence.
Right.
It looks to me like this is sort of, it's just too
much. Yeah. Well, for example, neuropathy.
Specific enough. It's not. Right. It's not linear enough, for lack of a better phrase. Like you need to connect the objective evidence to the impairment, to the limitation, to the job.
Yeah.
If you do that in straight lines, you may not even need to talk about chronic fatigue.
Correct. And right, if you have a nerve conduction study that documents severe neuropathy, right, you don't need to really talk about the chronic fatigue part. If you've got, severe arthritis in your spine documented by MRI, that's going to be, that's going to help explain why you have to, stand up or
falling while it's terrible has nothing to do with sedentary work.
Mm-hmm.
I mean, can you stand up? Can you sit down? Like, can you get into the workstation? The fact that you've fallen has almost nothing to do with doing sedentary or sitting jobs. And so you have to be aware that could be a really dangerous thing for you. But a vocational expert's going to say, well, I mean, you're not going to fall out of the chair, are you? That's
Right.
the question: is you're going to fall out of the chair? You know.
Right.
But,
They would certainly say you can't climb ladders, ropes, or scaffolds.
well,
or
yeah,
work
but you're doing a
that
desk
has
job.
equipment,
You're doing a desk job, so who cares that you can't climb ladders?
right.
You know.
Yeah, but I would agree. I think the things you've listed here, neuropathy is our nerve conduction study, arthritis and degenerative disc disease. What does the MRI show? You got to kind of break it down as opposed to saying, I got all these things, Judge, I'm disabled.
Yeah.
Look at each one and see where the evidence leads you. All right. M43 videos. I have cervical dystonia, but an SSDI for 24 years. I'm 65. Do DoorDash. Triggered my first trial period. Shall I use my allowed months for the next 2 years? I mean, again, I don't think you're going to really find that you're going to have a CDR at 65. You're getting close to retirement.
65 shouldn't the disability have already converted to retirement, so it's not going to matter?
Possible. I don't know. I mean, if he's 65 now, maybe it takes 66 before it converts automatically.
Yeah, I mean, a good question would be to call the local Social Security office and ask when your DIB is going to convert to RIB. Because once it converts to RIB, you have no issues with the disability. The only question is, are you making too much money that you potentially get taxed?
Yeah.
I would want to know when your RIB starts. And Social Security can tell you that without triggering anything.
Right, retirement. Okay. All right, so we got about 10 more minutes. So let's kind of zip through some of these. Rip says, ALJ never asked about medication changes or why dosage was increased. Could you appeal on that? I don't know. I don't know that you could appeal on that. That doesn't seem to me to rise to the level of reversible error. You know more about appeals than me, but
yeah, I mean, in the federal space, the short answer is, I got to see the decision. I mean, if you look at the decision, you can tell. I mean, if the judge doesn't, I mean,
if the medication changes were significant and there's ongoing attempts to control something with medication changes, that would say that's evidence.
I mean, let's say you were taking like Oxy 5s or whatever,
right.
and they increased them to Oxy 10s, and they increased the frequency of
right.
usage to 3 times a day,
and they give you morphine,
zombie,
right.
and they don't even mention it. That's pretty bad. Like
if
they took your blood pressure medicine and took it from 5 to 10, it probably didn't matter.
Yeah.
I know those are sort of extreme examples, but that's how extreme.
Yeah.
That's the spectrum that you're on, and the question is, where was that? Not discussing evidence is not near as big a problem.
Well, he said that ALJ didn't ask questions about it. The real question is, was it referenced in the decision? Is it relevant to?
Well, did you have a lawyer? Did your lawyer bring it up? Did your lawyer not bring it up? Were you not represented? Is there a reason it wasn't asked? I mean, there's a ton of questions.
Yeah,
it could be the basis, but I mean, that wouldn't be something we'd look at initially.
Right. All right. Sharon's one of my clients, and we're trying to get her past due benefits. They're telling her 90 to 180 days. And I'm seeing this on the NOSCR listserv that many cases that paying of past due benefits is being really, really delayed. It's just the personnel. I think they don't have enough people.
Yeah, I mean, that's a call your senator, make them do an inquiry. But I mean, yes. Depends on what payment center you're at.
Yeah, well, she's in Georgia, so this is Georgia can be a bit of a problem. All right, art of practice says when federal court reverses and remands, should the focus of the new hearing primarily be on what the reversal is based on? Should be on all the evidence? I think it's really on all the evidence. I mean, the reversal is the federal court's going to tell the judge to do something different, but you don't want to ignore other things that were going on as well.
Unless it's limited, unless the remand is limited to that specific issue, it's de novo review, and you need to go over everything here.
Yep. All right, Susan.
That's what the judges too. If it goes back to the same judge, a lot of times they'll cut you off. They won't even let you hear it too.
Yep. Susan says, Susan's the person in Noonan, Georgia. I'm 60 with severe osteoarthritis and depression on 9 different meds with bad side effects. Should I ask my adjudicator to look at the grid rules? Yeah, I think you should ask. I mean, that's the depression is.
They screw a lot of stuff up. They're not going to not look at the grid rules on a 64-year-old.
I think so too.
They might get it wrong, but
it could happen. Now, I don't think there's any problem in asking them to do that.
Yeah, for sure.
It's never a problem to say, please look at the grid rules. But 9 different medications, those are going to create what they call non-exertional impairments, which will, help eliminate transferability of skills and add to the equation. But yeah, being 64, severe knee osteoarthritis, even if you could do light work, you're going to be disabled under the grids. If you have any non-exertional impairment, which non-medications is going to probably give you, going to eliminate transferable skills. So that looks to me like a pretty straightforward grid argument, light even if you could do light work. Okay, pocket change. Recently appealed the recon stage, found medically favorable but denied, just received message for a post-entitlement appointment. I don't understand unless there's a problem with the date last insured. I don't really understand the issue here. Recently appealed, found medically favorable, but denied. That doesn't make sense to me.
Yeah, because if it was technical denial, they wouldn't have got to the medicals.
Yeah, I would agree. So maybe we're missing something there. Again, we're getting low on time, so let's move on. Christina, again, thank you, Christina, to remind everybody to leave a review. That'd be great. I really appreciate it. In fact, let me put that on the, I always do this, just to leave me a review if you feel it appropriate. Okay, let's see here. Chantette, hello. I'm not Mrs. Ginsberg. She's upstairs, but 49 years old, brain surgery, my right eye completely blind, right central vision, frequent urination, weight restriction, head cannot run forward, symptoms never sustain reconsideration. Longer. I mean, how much longer you'll have to wait? It just depends on their work, how busy they are. 49, it'd be better if you were 54 or 59. But again, you've got some significant issues here. They're just going to have to go through the process to make a decision on it.
In August 2023, though, I'd be trying to get somebody to call it.
I would agree.
Why in 20 months have you not got a?
Yep.
No, I mean, I have people who've been in the system almost that long.
Yeah, that's way too long. That's too
long.
Yep, I agree.
That for me, that'd be a red flag. Your case is lost in the system. Yeah,
it's and they do get lost in the system. Can applied in 2019 if an unable to work due to narrowing of the SWI. I don't know. Let's see what SWI is. SWI, medical abbreviation. I don't know what there's nothing coming up of SWI. So I don't know what the SWI is. Let's assuming it's cardiac of some type, maybe. I don't know. Or maybe the spine, in the spine. Again, I don't know, Ken, you have a question there, but the non-information really answer that there. Okay. Lady JJ, self-care, more. I have my hearing in September, wrote out a personal statement, have an appointment to discuss it, and it's in person. It's my second hearing. Okay, I'm real confused. If you have a hearing in September, what do you have on Monday? Don't know what that's all about, but personal statement, it's not going to have that much effect, quite frankly. Medical evidence is going to really move the meter more than personal statements. I think I'll just kind of leave it at that. But I don't know. First hearing was on Zoom, but you said you have a hearing in September, but then you have it on Monday, so I'm not sure what we're at there. Jeff Brown, what's the difference between a residual functional capacity form and a functional capacity evaluation? It's just two different terms for the same thing. Technically, residual functional capacity is a legal concept. It's residual means what's left over. Functional capacity, a judge makes a decision about what he or she considers to be a residual functional capacity. What is your capacity that exists after taking into account your medical issues? A functional capacity evaluation is a medical it's either a form that somebody fills out, where you go to a physical therapist and they do a bunch of tests. So
typically FCE is going to be an actual formal assessment done like in a workers' comp context, where they measure how much you can actually lift, how much you can actually push, pull, how many stairs you can walk, how long you can stand. It's going to be it's a formal
Right.
evaluation that's done by a physical therapist.
Right. It could take 2 days.
To do it.
It could
Functional
take 2 days.
capacity form is typically just going to be a form where you're asking someone to give opinion, a doctor to give opinion about your limitations.
Yeah. I mean, everybody calls them RFC forms, but I don't really like that because that's technically RFC is a legal determination.
Yeah, for sure.
You know, FCE forms is kind of just
FCE is usually an actual functional evaluation that's done in a workers' comp context.
Yeah, or it could
be usually not helpful either.
Yeah, it doesn't always have to be in comp context, but yeah, you're right. If it's done in a comp context, often is not. All right, Jay Rip, we got a time for just a couple more here. Has been 58, been a police officer for 34 years. Thank you very much, Jay Rip, for putting your life on the line for all of us. You know, I think a lot of us don't realize how difficult being a police officer is, and I, for one, appreciate what you've done. Serious neck and back issues from wearing gun belts and vests. 100% P and permanent total with VA, I'm guessing. Numerous other. I mean, I think that anybody who's 58 with a long work history and objective medical problems, back and neck problems that would logically arise from your work and the type of work you've done, I think it's, you know, probably a decent argument, especially if there is some objective evidence, some MRI that shows something going on. You probably all you need to do is get yourself limited to light work to meet the grids. So I think probably you have a pretty good shot.
I would say so.
Okay.
Straight take in my office for what's worth.
Yep, I would agree.
We would take that case.
Okay. All right, let's see what we got here. All right, Christina's reminding everybody, please press the button. Absolutely, please press the button. All right, so we're getting kind of low on time here, so let's just go. I want to make sure that people know, Chad, how to reach you.
Yeah, sure.
You are you've been practicing law for many years in disability, so tell the folks how they would reach you if they want to get a hold of you.
Easy, chadbrownlaw.com. You can contact us there. You can contact us at info@chadbrownlaw.com. But honestly, just I really love people do is check out our podcast. We've got I run a podcast called the Disability Expert Podcast. Pretty much every week, sometimes scheduling gets in the way, but pretty much every week I'm interviewing disability experts all over the country. It's usually it's very topical based on what those experts want to talk about. So we cover a huge range of issues. Jonathan and I did a 2-part episode. I think the first part's going to drop on his YouTube page sometime in the next week or so, and then the second part is going to drop on my at CB Disability Law, which is my YouTube page. But you know, mainly if you want to call us, great, but really just check out the podcast, follow Jonathan's YouTube page. You know, there's only a small number of us out there who are actually producing content and really engaging people with sort of very practical type knowledge. And you know, that's my thing, is just make sure you're supporting the people who are out there, you know, helping. I'd love for you to watch our podcast. I think it's relatively new, but I think it's going to be a really good source of people as we put it together.
Yeah, and I think this is an area of law where people tend to help each other. This is not like uber competitive. You know, most, I mean, and the NOSCR listserv, people are always asking questions, answering them. So most people want to help each other. There's plenty of work out there for anybody who wants to do this kind of work. And I think, you know, most of us who do this, the goal is to get deserving claimants the benefits that they have to really fight to get, unfortunately, against really kind of an unfair and sometimes uncaring system. So absolutely. Now you also, besides doing disability work, you have a insurance agency, do you not?
Oh yeah, that's right. Oh, I completely forgot. Yeah, we have a own a company called CBIG. CBIGcares.com is our website, and we have a Medicare specialty insurance agency that I started six years ago, and we work almost exclusively with Medicare beneficiaries who receive their Medicare because they're on disabled. So when you receive disability, after you receive your benefits for 24 months, it ends up typically being 29 months from when you're found to be disabled. But you have to receive the benefits for 24 months, you get Medicare. And our experience was that the average person who got on disability was getting poor to bad advice on how to navigate Medicare, how to get subsidies. Medicaid subsidizes Medicare for a lot of people. There's a tremendous number of Medicare Advantage plans, which are somewhat controversial in some areas, but if you're under 65, you really can't buy a supplement. You almost have to go into a Medicare Advantage plan in most states. So really, it fills the gaps in Medicare. The folks who work for me in that company are experts in disability law. They're experts in Medicare because they have to see how those work together. And so that's cbigcares.com, or you can email me at chad@cbigcares.com, and we help people all over the country. We work with lawyers and their clients in addition to my law firm's clients. So that's another whole topic, but yeah, that's been a very rewarding.
Yeah. But maybe we'll do another one. We'll focus on the Medicare side.
Oh yeah, sure, love to.
But I will tell you that, doing disability work for 30 something years, obviously I tell my clients, after you've been approved for 2 years, you become eligible for Medicare. But you look into Medicare and like it's a dizzying array of options. I mean, it is confusing. It would be a kind word for it. And
it's very, and the average person who goes on Social Security Disability needs to be in a Medicare Advantage plan. And Medicare Advantage plans are sold on a county by county basis. So like, it's not even like you can go and say, if you're in Brunswick, Georgia, your options are very different than if you're in Atlanta, if you're in, or Valdosta or Savannah. Like just in the state of Georgia alone, there's completely different regions. And in those regions, the counties have different plans that apply for you. And so in one county, honestly, United Healthcare might be the best option, but you could go literally the next county over and like you need to be in a Humana plan or an Anthem or whoever it is. The point is that it's very, very, it's very specific to where you live. When you combine that with it needs to meet your specific needs, which are really high with disability clients. I mean, they have a lot of doctors, a lot of meds, complex situation, and they're on fixed and limited incomes. So how do you take someone that has a fixed income, has a lot of medical expenses, needs medical treatment, and work them all the way through that system? I mean, it can get really complex. It's really rewarding when we work with on the insurance side. That's something I'm really proud of, and we just really we just hired one of my 20+ year disability paralegal came to work for me in the insurance agency just because we wanted to have people who have that knowledge of the whole disability process in that system so that they can really understand the issues that our clients are going through on the insurance side.
No, it's a really confusing area. And like I said, maybe we'll do another one of these. We can talk just about that, or maybe do a special episode just about that, because it's confusing. It's really confusing. So okay, we are right at 2 hours and 7 minutes actually. So I appreciate your time, Chad, for spending a couple hours with us tonight. Thank you.
Once I got the battery plugged in, I know.
I had
to get it walk around. Once I got the battery plugged in,
before we started, Chad's like, I only got an hour battery. I'm like, well, that's not gonna be. I got 2 hours of questions. It's not gonna be long enough. So, but I appreciate that, and it's there's a lot of questions about Social Security. It's definitely a lot of changes in the last year or two, and you hope that that things seem to be settling down a little bit, but I know there was a lot of concern about big changes coming to it. But I think that bureaucracies have a way of getting things back to even, and Social Security is certainly a big bureaucracy. But we'll just have to kind of monitor, see what's happening. The big issue is obviously they don't have enough people, and things are taking a long time, and in cases that fall through the cracks can be a real problem. But
we tell clients all the time, look, you can focus on what you can control. I mean, I can't control what Congress is going to do. I can't control what the president's going to do. I can't control what Social Security Administration is going to do. I can tell you what the rules are today. Let's focus on your case. Let's focus on your facts. Let's focus on your impairments. Let's focus on how do we win your case. But it's so easy to just be overwhelmed by all the stuff around us, but you can't control it. I mean, it's not that all of us don't wish things were different. We all do, but you can't control it. Focus on what you can focus on.
Yep.
Because being sidetracked is probably one of the, losing focus in your case is one of the easiest ways to lose.
Yep. Okay. Well, Chad, hang on for 1 second, but we'll end the stream on that, and we'll see everybody next week.
Very good.